looks like Mr. Azeltine, I may be pronouncing that wrong, is had a fairly recent warrant. I would, if we're comfortable addressing that on the record.
Yep, Mr. Azeltine, are you able to turn on your microphone?
Can you hear me now?
Yes, sir. Okay, it looks like you missed your hearing on July 16th, just a few days ago.
I am, without recourse, sui juris, in propria persona, the living man, and not representing the incorporated Ty Warren Azeltine entity. I am the affiant of the affidavit of truth filed in this case, April 26th, appearing specially and not generally under threat, duress, and coercion to correct the mistaken identity misnomer of the defendant, and notice this court to dismiss this case sui sponte for failure of joinder, failure to serve the complaint, failure to state a claim upon which relief can be granted, and lack of jurisdiction.
Before we even begin, understand what you're about to witness. This isn't just a traffic hearing or a missed court date. This is a collision between internet legal mythology and real-world courtroom procedure. Today we've got two self-identified sovereign citizens, both convinced they've discovered a legal loophole that exempts them from government authority. They reject their legal names. They challenge jurisdiction. They invoke affidavits of truth. But here's the reality. Courts do not operate on wordplay. They operate on statutes, geography, and burden of proof. And what makes this fascinating is how simple both of these situations could have been resolved. One man only needed to confirm his identity to clear a warrant. The other only needed to argue the facts of a traffic stop. Instead, both choose ideology over strategy. Watch how the judges respond: calm, procedural, controlled. Because when rhetoric meets record, only one of them actually matters. Let's break this down.
And I have some questions before I feel comfortable with this court moving forward. Has someone entered a plea on behalf of the defendant?
All right, I'm not going to be able to address this case unless I have assurances that the defendant, Ty Azeltine, is the person here, and I'm hearing a lot of nonsense that doesn't address directly, that rather obfuscates the clarity on who you are. If you're not Ty Azeltine, then you're a spectator and you're welcome to stay. If you are Ty Azeltine, I'll address your warrant, but I will address no other issues in this hearing because this hearing is limited to quashing warrants and setting court dates. So are you Ty Azeltine?
Does the caption of this case not say Ty Warren Azeltine in all capital letters?
Your Honor, I can speak with Mr. Azeltine in a breakout room if you prefer, or...
Well, he's not represented by counsel and hasn't been throughout this case.
I see that he's refused counsel.
Yep. If you're Ty Azeltine, just tell me that. If you're not, then I'm going to let you spectate for the rest of the court calendar until we're done.
I am the affiant of the affidavit of truth. And if you look at the affidavit, it will clarify who it is that I am. There are two.
Okay. All right. I've muted your microphone. It appears to me that you don't claim to be Ty Azeltine, so I'm going to strike Ty Azeltine's hearing, and the matter will be, the warrant will be left outstanding. And Heidi, no one is eligible to appear on Zoom in this case. They have to apply in person for a warrant quash. All right. And sir, you're free to remain and watch the rest of the calendar. We're going to go on to other people who are here.
Right away, notice the opportunity being handed to him. This hearing is about a warrant from a missed appearance. Courts frequently give defendants an easy path to fix that. Show up, confirm who you are, accept responsibility for missing the date, and get rescheduled. That's it. Instead of taking the straightforward route, he pivots into sovereign citizen language designed to separate himself from the legal name on the docket. But here's the flaw. If you refuse to confirm you're the person named in the case, the court cannot quash the warrant. Procedure requires identity confirmation. The judge isn't debating philosophy, she's asking a yes or no question. And the longer he avoids it, the more he tightens the procedural knot around himself.
Calling case number 24, RO04189. This is people of the City of Royal Oak versus Anthony Winston Mathis. Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee of the trust.
This living man argument is a staple of sovereign citizen ideology, the belief that courts only have jurisdiction over a corporate fiction represented by a name in all caps. But jurisdiction in local courts isn't mystical or contractual in the way he implies. It's territorial and statutory. If the alleged conduct occurred within the county, and the individual is physically present or properly summoned, jurisdiction attaches. The judge's response is methodical. Narrow the issue, demand clarity, refuse to engage in abstractions. Courts don't dissolve because someone disclaims representation of their own name. And by refusing to answer directly, he's not outmaneuvering the court. He's preventing himself from accessing the relief he came there to request.
Well, Mr. Mathis, today's the date and time for your informal hearing. The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you are operating a 2024 Ford Edge, black in color on 11 Mile Road, near Washington, in the city of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have three options and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility and the court will swear the parties and will take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by law.
No, I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran and Mr. Mathis, please raise your right hands.
I do have a question.
And just like that, he leaves. This is the part that often gets overlooked. Judges, especially in lower courts, routinely show leniency when someone appears voluntarily after a failure to appear. Warrants get quashed all the time under those circumstances. But that only happens when the person participates in the process. By refusing to acknowledge identity, he effectively disqualified himself from the reset button sitting right in front of him. The warrant remains active not because the system was unfair, but because he wouldn't satisfy the most basic procedural requirement. That's not defiance, that's self-sabotage.
Do you solemnly swear the testimony you shall give before this court shall be the truth, so help you God?
I do.
Thank you very much. Please proceed.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge, black in color, with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
Very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, Magistrate, at that time.
That's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it. Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So, I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in terms of who's present on behalf of the city of Royal Oak?
Where is the city of Royal Oak?
Now we move to the second case and notice the contrast in structure. The magistrate clearly outlines three options: admit responsibility, admit with explanation, or deny and proceed to testimony. This is a civil infraction, not a criminal prosecution. When he says, "I don't plead to anybody but God," it sounds bold, but it ignores the fact that he requested this informal hearing. By requesting it, he voluntarily invoked the court's jurisdiction. You can't ask a court for a hearing while simultaneously denying its authority to conduct one. The magistrate stays composed, repeats the procedural requirements, and keeps the focus on the legal framework, not the theatrics.
Please bring the.
The court doesn't understand your question. Are you asking where it is on a map, or where is the officer?
No, I know exactly where it is on the geographic location, but where are they right now?
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the vehicle code
as I
of the
was
city of
traveling,
Royal Oak as it is adopted.
as I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward as far as the injured party. No one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case
Why are you trying
under
to
the Motor
charge
Vehicle
me?
Code as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
No, it isn't. If you guys can't bring any injured party.
When he challenges jurisdiction, this is where strategy completely collapses. Jurisdiction in a traffic infraction case is based on statute and location. The alleged violation occurred within the city. The court has authority over that city. That's the equation. Instead of disputing whether the light was red, whether the officer had a clear view, or whether traffic conditions justified his movement, he chooses to argue abstract sovereignty. But in civil cases, the burden of proof is only a preponderance of the evidence, more likely than not. If the officer's testimony stands unrebutted, that standard is easily met. Ignoring the factual battlefield means forfeiting it.
You guys are.
Officer Moran, any rebuttal testimony?
No rebuttal testimony.
Thank you so much. Mr. Mathis, the burden of proof in a civil case is a mere preponderance of the evidence. The officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of two cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that serves $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis. If you take exception to the court's ruling, you may post a bond in the amount of $175 within 7 days, and the matter will be placed upon the formal hearing docket of the chief judge of the district, and at that time, the city of Royal Oak would be represented by a city prosecutor. So either a bond or a fine of $175 payable within 7 days. That completes your hearing. Thank you.
All right.
The bring forth the injured party argument is another common misunderstanding. That requirement applies in certain criminal contexts or tort cases involving direct harm. A civil traffic infraction doesn't require a physically injured plaintiff to appear. The officer represents the municipality enforcing its code. At this point, the magistrate has explained the law multiple times. He still has a chance to present facts about what actually happened at the intersection. Instead, he repeats a legally irrelevant demand. And in court, repetition without relevance doesn't strengthen a position, it weakens it. With no factual rebuttal on the record, the officer's testimony becomes the controlling narrative.